My name is Titinor Picabaro and I am tasked to discuss Republic Act 9995, which is an act defining and penalizing the crime of photo and video voyeurism, prescribing penalties thereof, and for other purposes. So, what is the purpose of this Republic Act? This was happened when a highly publicized sex videos of celebrities rocked Philippine society in May 2009 and was quickly shared online and later distributed through DVD in the streets and sidewalks. In response to this, the Congress enacted Republic Act 9995, Anti-Photo and Video Voyeurism Act of 2009, to prevent the publication and distribution of the material in the future. This law also prohibits recording videos or taking photos of a sexual act, the male or female genitalia, and of the female breast, and among others, without the consent of the persons featured in the material. The law ultimately seeks to prevent the reproduction, distribution, and production of said material, regardless of whether or not the persons featured consented to the recording. So this Republic Act mainly geared towards protecting the privacy, honor, dignity, and integrity of a person. Under Section 3, for the purposes of this Act, the following terms are defined. First is broadcast. So what is broadcast? It refers to make public by any means a visual image with the intent that it be viewed by a person or persons. Okay. What is capture? Capture, with respect to an image, means to videotape, photograph, film, record by any means, or broadcast. Female breast refers to any portion of the female breast. So, if the photo shows only the side of a female breast, only showing the nipple, is this still covered by the law? The answer is yes. The term female breast includes any portion of the female breast. What if the photo shows the breast of a man? Is this still covered by law? The answer is no. The law only covers female breasts. What do you mean by photo or video voyeurism? This refers to an act of taking photo or video coverage of a person or group of persons performing sexual act or any similar activity, or of capturing an image of the private area of a person or persons without the latter's consent, under circumstances in which such persons has or have a reasonable expectation of privacy, which later will be defined on the next slide, or the act of selling, copying, reproducing, broadcasting, sharing, showing, or exhibiting the photo or video coverage or recordings of such sexual act or similar activity through VCD or DVD, internet, cellular phones, and similar means of devices without the written consent of the persons involved, notwithstanding the consent to record or take photo or video coverage of same was given by such persons. Now, what is private area of a person? It refers to the naked or undergarment-clad genitals, pubic area, buttocks, or female breast of an individual. If there is an undergarment covering the private parts, is this still covered by the law? The answer is yes, based on the definition above. The genitals, pubic area, buttocks, or female breast of an individual may be naked or clad with undergarment. Under circumstances in which a person has a reasonable expectation of privacy, refers to the believing that he or she could disrobe in privacy without being concerned that an image or a private area of the person was being captured, or circumstances in which a reasonable person would believe that a private area of the person would not be visible in the public, regardless of whether that person is in public or private place.
What are the prohibited acts under RA number 9995? Section 4 of the said act states that it is hereby prohibited and declared unlawful for any person to take photo or video coverage of a person or group of persons performing sexual act or any similar activity, or to capture an image of a private area of a person or persons, such as the naked or undergarment clad genitals, public area, buttocks, or female breast without the consent of the person or persons involved, and under circumstances in which the person or persons has or have a reasonable expectation of privacy. B. To copy or reproduce, or to cause to be copied or reproduced such photo or video or recording of sexual act or any similar activity with or without consideration. C. To sell or distribute, or cause to be sold or distributed such photo or video or recording of sexual act, whether it be the original copy or reproduction thereof. And D. To publish or broadcast, or cause to be published or broadcast, whether in print or broadcast media, or show or exhibit the photo or video coverage or recording of such sexual act or any similar activity through VCD or DVD, internet, cellular phones, and other similar means or device. The prohibition under paragraphs B, C, and D shall apply notwithstanding that consent to record or take photo or video coverage of the same was given by such person or persons. Any person who violates this provision shall be liable for photo or video voyeurism as defined herein. The prohibition under paragraphs B, C, and D shall apply notwithstanding that consent to record or take photo or video coverage of the same was given by such person or persons. Any person who violates this provision shall be liable for photo or video voyeurism as defined herein. So what is the penalty for committing any of the prohibited acts? Violation of RA 9995 is punishable by imprisonment of not less than 3 years but not more than 7 years, or a fine of not less than 100,000 pesos but not more than 500,000 pesos, or both, at the discretion of the court. If a juridical person is proven guilty of violating this act, its license or franchise shall be revoked. If a public officer or employee or a professional is proven guilty of violating this act, he or she shall be administratively liable. If an alien violates this provision, he or she shall be deported after serving his or her sentence and payment of fines. So, are these materials admissible in evidence? So, as a general rule, any record, photo, or video, or copy thereof, obtained or secured by person in violation of the preceding sections, shall not be admissible in evidence in any judicial, quasi-judicial, or legislative or administrative hearing or investigation. However, a peace officer who is authorized by written order of the court shall not be held liable for holding the record or any copy thereof as evidence in civil, criminal investigation, or trial of the crime of photo or video voyeurism, provided that such written order shall only be issued or granted upon written application and the examination under oath or affirmation of the applicant and the witnesses he or she may produce. And upon showing that there are reasonable grounds to believe that photo or video voyeurism has been committed or is about to be committed, and that the evidence to be obtained is essential to the conviction of any person for or to the solution or prevention of such crime. So, what are the salient points of RA 9995? The male's breast is not covered by the law, while any part of the female breast is, even if the photo shows only the side of the female breast without the nipple, the offending party would still be liable. Even if there was consent to the taking of the photo, if there was no consent to the sharing or exhibition, then the offending party would still be liable. The mere copying or reproduction of said material will make one liable under the law regardless of the reason or whether one profits or not from such act. The mere showing of the material on one's cell phone would violate the law. And lastly, even if there is an undergarment covering the private parts, the offending party would still be liable.